Beach Code Enforcement Special Magistrate hearing for March 11th, 2024. My name is Erica Agello, and I am the appointed Special Magistrate to hear today's cases. I am a practicing attorney licensed by the Florida Bar and am board certified in city, county, and local government law. I have been appointed to this position in accordance with the authority set forth in Chapter 162 Florida statutes and the City of St. Pete Beach Code of Ordinances. I am not an employee of the City of St. Pete Beach and do not represent the city here today. I do not confer with the city's code enforcement officers outside of the hearing process about your cases. It is my role to fairly and objectively review the matters presented. As such, I would like to advise you of certain matters related to today's proceedings. Today's matters will be heard in the order on which they appear on the agenda unless otherwise agreed. Every effort will be made to hear all persons having relevant evidence, arguments, or comment related to the specific case that is being heard. If you wish to speak today, it is necessary that you be sworn in, which I will do momentarily. All testimony given will be done so under oath. In all cases, since the city has the burden of proof, the city will present its case first. The respondent will then be given an opportunity to refute the city's allegations. Formal rules of evidence do not apply to this proceeding. However, I will make sure every effort is garnered to ensure that fundamental fairness and due process is afforded to all parties. After hearing all relevant evidence, I will issue an order. The order will be reduced to writing and all parties will be provided with a copy, so please ensure that we have your current address or email address. Additionally, you are advised that I do not have the authority to grant you a variance, permit, or special exception of any kind. My role is solely to determine whether a city code has been violated and under some circumstances to provide a reasonable time to correct the violation by whatever means are available to you. Please be advised that you may be subject to a fine and a lien may be recorded on your property if the violation is not corrected by the compliance date, if one is provided. If you wish to present any evidence today, please sign in before you speak at the podium, and it is also necessary that you swear or affirm to tell the truth. Therefore, at this time, I will swear in any witnesses. Anyone wishing to speak today, if you could please stand and raise your right hand to be sworn. Do you swear or affirm that the testimony you are about to give is the truth, the whole truth, and nothing but the truth?
Yes.
So sworn. Do we have any changes to the agenda this morning?
Yes, Madam Special Magistrate, Pete Dewar, Code Enforcement Manager on behalf of the City of St. Pete Beach. We're adding case number 2023-0255 as a lien reduction, 471st Avenue. Thank you.
You said 2023-0255.
471st Avenue. And that's under lien reduction.
Okay.
Thank you.
Okay, any other changes to the agenda this morning?
No, ma'am.
Okay, so moving on to our first agenda item, 2A, case number 2023-0602, City of St. Pete Beach versus Ping Pong Partners, LLC. Would the city like to give us an update, please?
Yes, good morning, Special Magistrate. Louis Cruz representing the City of St. Pete Beach Code Enforcement. It looks like they are on track to get their permit. They do need an NOC, the notice of commencement from the county. They also need to pay the fees that are associated with obtaining the permit, as well as just a pending building review. But it looks like they're getting everything in line that needs to be done so they can obtain the permit to its entirety.
Okay, so at this time, is the property owner in compliance per the city or still non-compliant?
Still non-compliant until they actually fully obtain the permit for the dumpster enclosure.
Okay, and briefly remind me, I do recall at the last hearing we had a notice issue, and so we postponed it until today's date in order to give notice to the respondent to prepare any response to the city's violation or to the prosecution. Have you been in contact with the respondent, or do you know if they intended to attend today?
Yes, they are here today.
Okay. All right, anything further from the city?
Nope, that'll be all.
Just to clarify, I think the city is going to request just a continuance.
An additional continuance?
Yeah, just because since they've done what they've done, maybe a status hearing in April.
Okay. Okay. Would the respondent like to please come up, and if you have anything to add to that? And please state, of course, state your name for the record.
Adam Harden, 220 West 7th Avenue, Tampa 33602. I was sworn in on behalf of the applicant Ping Pong Partners. We agree with the request for a continuance to the next scheduled hearing. Thank you.
Okay. And does this, I mean, do both of the parties think that it can be complied with by the next date certain? in April?
Yes, the permit application has been made, and the planning and zoning approval has been obtained, and we're in line for the building approval or review.
Okay. And our next hearing is scheduled for April 8th. Is that correct? That is correct?
Yes, ma'am.
Okay.
It is.
So then I will go ahead and grant a continuance until the April 8th hearing at 10 a.m., and we will reconvene for another status check at that time.
Thank you.
Moving on to case 2A, which is case number 202300513, City of St. Pete Beach versus April Elliott and David. You know, I got it last time, and I don't think I'm gonna be able to do it this time. Rybarsik?
Yes.
Okay. Do we have an update from the city on this case?
Yes, could you, Louis Cruz representing the City of St. Pete Beach Code Enforcement, could you put on the overhead for me, please? I do want to announce these are a true and accurate representation of what I have witnessed. Just an update on the dumpster enclosure. It looks like they haven't done anything that they, needed or were asked to do. They reached out to me shortly after the special magistrate hearing and then haven't heard from them since. And it looks like they just reached out to me early this morning, a couple minutes before this hearing today, asking if, it says, unfortunately, neither my husband nor I are able to attend this morning's hearing, basically stating that they had a lot of people coming in that for potential buyers from in and out of state, weren't able to get it done. They said they have conferred with a general contractor. They've gotten a quote for the project, which they did not give to me, and he is able to complete the removal as soon as there is a lull in showings. Previously, the city had asked for fines for $250 per day from 1/5/2024 until compliant, and the city would like to steadfast with that.
Okay, and if I recall correctly from the last hearing, there was a question of whether or not it could just be removed or if it had to be replaced. Did the city make that determination? And if
Yeah.
so, what was that determination?
They could remove it. We kind of were talking about it previously at the last hearing, if whatever was financially viable for them, since they are trying to sell it. And I told them whatever they would like to do, just keep me updated, let me know, so I can, update my findings and go from there. And they had not reached out until today, this morning.
Okay. And is there anyone here on behalf of the respondent? Okay. So my previous order gave them until today to confer with the city to determine if the dumpster enclosure could be removed or if it needed to be replaced, and to make a good faith effort to complete the removal or replacement before March 11th. It seems to me that reaching out to you once during that time period to find out, to let you know that there is a quote, not letting you know what the quote is, not giving you a time frame, just giving you a general, there's a lull in showings to remove it, doesn't necessarily constitute a good faith effort, especially if the determination was that it could be completely removed. It seems to me that that shouldn't be a very difficult task to undertake, as opposed to having to get permits and reconstruct. So, because of that, I am going to find that there is a violation, or I have already found them in violation. I'm going to find that they are continuing to be in violation as of today's date. And I am going to assess a $250 a day fine. However, I'm going to do that from today's date until the property owner comes into compliance, plus the administrative costs of the city. And it is the respondent's responsibility to notify the city once the property comes into compliance.
Correct. And Madam Magistrate, I just want to specify our administrative fines are $325.
And $325 in administrative fines.
Thank you.
Thank you. Okay, moving on to agenda item 2C, which is case number 202300590, City of St. Pete Beach versus Gabby 2022 LLC. Would the city like to update on this case?
Yes, thank you, Special Magistrate Louis Cruz, representing the City of St. Pete Beach Code Enforcement. It looks like the property owner did obtain a permit. You gave them till 2/22/2024. The permit was issued 2/29/2024. So the city will be asking for $250 a day from 2/22 until 2/29, plus administrative costs totaling $325.
Okay. Is there anyone here, and the property is, you said, now in compliance as of 2/29/2020?
Yes, yes, ma'am.
24. Okay. Is there anyone here on behalf of the property owner? You could please come up, state your name and affiliation for the record, and if you have the authority to speak on behalf of the property owner.
Good morning, Bob Kenny, Certified General Contractor, 1469 Jacaranda Circle South, Clearwater, Florida, 33755. You have my authorization from the January meeting. We did obtain the permit on 2/29. It was 5 days after the deadline set. If we're to bear the responsibility of the 5 days of fines, I think an explanation is part of that, in that personnel at the city have changed despite numerous attempts to reach the former code compliance officer. We got no phone calls back, no help. The sprinkler issue continued for forever. At some point, the previous official was dismissed. We got a new official, met with him immediately, and he was very helpful in that I kept trying to explain to the former official that based on the work that was done, the violation was issued on, sprinklers weren't required. And we kept being told, no, sorry, you're going to do it. I said, show me the code. I could never get a response, never get an accurate statement other than, well, we're not going to debate it. I said, that doesn't help. So it took about 3 weeks, but once the new official was in place, we met him on site, went over all of the work that had been done, explained to him, and he says, look, you don't need to do this, you don't need sprinklers, you don't need this, finish this paperwork, submit it to me, we'll get it approved. And so we did immediately. Just as soon as we could get the requested changes and the accurate information he wanted, we submitted. And so we waited, I'm going to say about 3 weeks for the permit to be issued. Made a few follow-up calls letting him know, hey, we're against a deadline here, we'd like to get it issued. So the delay and the problem that existed wasn't of our causing. It was based on this building official, and now that he's gone, things are moving fine. We've got a permit. We've had 2 inspections since the permit was issued. Things are moving along just fine. So I understand the purpose of the fines and the deadlines is to force compliance, but if we can't get cooperation from the city or phone calls back and we're dealing with a problematic official, then I would argue that perhaps those fines should be waived, at least the penalty fines. If there's administrative costs, I understand that. I'm on the code enforcement board up in Clearwater, and I understand how that works, but
Sure.
that would be my request.
Okay. Thank you very much.
Thank
Anything
you.
further from the city? Okay.
And thank you, sir. Special Magistrate, this was a problem property. I did about 3 or 4 stop work orders on there, this being one of them. And ever since the contractor did get on, things have been going much smoother than they were before when they were doing the unpermitted work. But I just wanted to state this had been multiple times we've had to deal with this property.
Sure. I understand that.
And just for clarity, as of the date of the first order on January 11th, we had already had a new building official.
Okay.
So nothing changed from January 11th till today.
Sure. Well, obviously I found that the property is in violation. I appreciate the appeal to have a reduction in the fines or have no fines assessed whatsoever. However, the violation that was here was because of it needed to have an after-the-fact permit. The fact of the matter is if the permits were secured prior to this, there wouldn't be any code enforcement action. There wouldn't be any necessary needs for the imposition of fines or fees. It could have been avoided entirely. I do appreciate that you getting a contractor involved and moving the process forward. So I am going to assess a fine, but only of $150 a day from 2/22 to 2/29, plus the $325 in administrative costs. And I will get you an order to that effect.
Thank you for consideration.
All right, moving on to new cases. Agenda item 3A, case number 20240101, City of St. Pete Beach versus Jesse Head. Would the city like to make its presentation?
Yes, good morning, Madam Magistrate. Steve Rivera, on behalf of the City of St. Pete Beach Code Enforcement. Case number 20240101, respondent's Jesse Head. Violation address is 3510 Casablanca Ave. Violation description, the property is in violation of section 9.2, permitted principal and uses and permitted uses and structures of the Land Development Code of the City of St. Pete Beach. Case summary, initial inspection was 2/13/2024. Notice of violation compliance date was 2/24/2024. Notice of hearing dated and posted 2/15/2024. Just for clarification, the compliance date, there was two violations on the property. One of them was I&I, and I put that in there, so that's why the compliance date is different.
Okay.
The following is a true and accurate representation of what I witnessed. This is the affidavit of posting. This is the listing on Airbnb. Shows the host, Jesse. Shows here 3 nights you could book at $399. Minimum stay shows here also 3 nights, so this was for the initial notice of violation that I gave him the compliance date to fix the listing. But there was 2 rentals in November, showing for the I&I. Corrective action. The property is in the RU2 zoning district and can only be rented monthly. The property is compliant. Recommended fine $500 per stay in November for the irreparable and irreversible violation, plus the $325 administrative costs. And that concludes my presentation.
Okay, I do have a couple of questions. So my understanding, so there were the two, you're saying the compliance date was different because there was a violation for the actual rentals and then a violation on the advertising.
So I gave him an option to correct the listing for it being less than monthly. I did put it in the notice of violation that the 2 rentals in November was considered irreparable and irreversible, and that it was going to be scheduled for the March magistrate.
March 11th, 2024?
Yes.
Okay. And then, okay. So they complied with the advertising, is what
Correct.
you're saying, but they did not comply, well, they can't comply with the, okay.
They couldn't comply with the
Because
the
there's
November rentals, but they complied with the advertising.
Correct, got it.
And I believe Mr. Cruz is grabbing the review policy, but I do want to mention, Madam Magistrate, I spoke to a Josh Burnett, who's the attorney for Mr. Head. He admitted to the violation, and we essentially, the magistrate deems this irreparable and irreversible, which we believe it is. $500, they've agreed to the $500 per comment, plus $325 administrative.
Okay. Okay. And is there anyone here on behalf of Mr. Head, of Jesse Head, attorney or otherwise? Okay.
If we could, just for the, is that the review policy? If we could,
Yes.
just for the record. Thank you.
You overhead, please.
Okay. Will be accepted as evidence.
Thank you.
All right, I am going to find that the property was in violation of the 2 rentals as they are irreparable and irreversible. I am going to assess a $500 fine for each of the 2 rentals in November of 2023, plus the administrative costs of you said it was $325?
Yes, Madam Magistrate.
Of $325, and I will get you an order to that effect.
Thank you.
Okay, moving on to item 3B, case number 2024-0021, City of St. Pete Beach versus Stephen D. Lower. Would the city like to make its presentation?
Yes, thank you, Special Magistrate. Louis Cruz representing the City of St. Pete Beach Code Enforcement. And respondent is Stephen D. Lower. Violation address is 505 67th Avenue, unit number 10. Violation description, the property is in violation of section 98-123.1, permits required, and 98-65, unsightly conditions 1B and C of the Code of Ordinances of the City of St. Pete Beach. Case summary. The initial inspection was 1/5/2024. Notice of violation dated 1/11/2024. Notice of violation compliance date 2/1/2024. Notices of hearing dated and posted on the property 2/27/2024. These are a true and accurate representation of what I have witnessed. Affidavit of posting at 505 67th Avenue, Unit Number 10, February 27th, 2024. This is a bathroom remodel that was left in disrepair from an open permit. The shower enclosure was never finished. Not sure. Using the bucket to possibly use the toilet properly. There's mold and water stains all over the floor and the walls. The sink was unfinished. And the corrective action. Property must have the permit reinstated or a new permit opened by a new general contractor for the bathroom remodel that has been left in a state of partial construction beyond the valid timeframe of the previous permit. The property is not compliant. The recommended fine is $250 per day from 2/22/2024 until property is compliant, plus $325 in administrative costs.
Just to clarify, Mr. Cruz, you said 2/22. Did you mean 2/2? I believe the notice of violation gave them until February 1st.
Yes, yeah, February 2nd, 2024. Yes, sorry about that.
Okay, I do have a few questions. First, you had referenced there was a previous permit that was pulled for the construction.
Yes.
You cited them for permits required, meaning they had done previous work under a permit which was required and given to them. Do you have any evidence to support that they did work without having a permit?
Not that they did work without the permit, but they didn't fulfill everything that was needed. Obviously, they obtained the permit, but you still have to do your inspections to complete the permit all the way to its entirety on the building division end.
Sure.
And they were not able to do that due to, it looks like from my knowledge, from what I gathered from the property owner, that it was left like that by a contractor that he paid, unfortunately, and it is very unfortunate, but that was left like that. And the reason this was brought to my attention is from an HOA president reaching out. It looks like that shower may be leaking into the unit underneath him, and that was the reason that I was out there at that time. They didn't do the work while not having the permit, but they didn't fulfill it all the way to its entirety.
And how were you able to access the unit?
I was given access by the property owner.
Okay, so the
Stephen
property
Lower.
owner did give you consent? to
Yes,
enter
yes,
them.
ma'am.
Did you have any conversations with him with regard to the state of the bathroom in disrepair?
Yes, I had talked with him when he had let me in. He kind of let me know a rundown of him kind of getting left high and dry by the previous contractor that he paid to do the work properly. He does live in California and he does come here quite frequently, but I don't know if he was here at the time while this was going on. I have no idea, but he is trying to do civil litigation against him for what was done, or technically what was not done, in the name of the permit and the name of the money that he had given to him. And unfortunately, it's been left like this. The permit expired 5/1/2023. Notice was given out to the contractor, who is the contact for the permit, and the contractor was also given notice about this, as well as being referred to the PCCLB for not finishing out the permit properly.
Okay. All right.
May I ask a
Further
question?
from the city, you may.
I do have a question. Do you know, or does Ms. Boland know what work the initial permit was issued for? And if you don't, that's fine. I'm just curious.
Boland is here.
Thank you.
We'll have Ms. Boland do that, please.
Good morning. Good morning. If you could just kind of state your name and position with the city for the record.
Joanne Bolin, Permit Administrator. Initial permit 2202202, description, scope of work, bathroom remodel, tub to shower, install new kitchen cabinets, and hardware. They never submitted a notice of commencement. The reviews were approved. They never had an inspection. Expired letter was sent out to the contractor and also to the subcontractor, Estrella Plumbing, and the contractor was reported to the PCCLB, I believe, in May.
And do you know if there was any contact or any notification sent to the property owner as well?
Not to the property owner, just to the contractor who owns the permit.
Okay,
May I ask a question?
you may.
So, Ms. Boland, the permit that you just stated for the work, that was, can I just assume that it was specifically for bathroom,
Bathroom remodel, tub to shower, and install new kitchen cabinets
kitchen cabinets as well?
and new hardware.
Okay. No further questions, Madam Magistrate?
Okay. Is there anyone here on behalf of the property owner, Mr. Lower?
Yes, ma'am, I'm the property owner.
Okay, if you would please come up, just state your name and address for the record, and anything that you'd like to say to respond to what the city has stated.
My name is Stephen Lauer. The property is 505 67th Avenue, Unit 10, St. Pete Beach, 5706. And I'm the property owner.
Okay. Do you want to add, do you have anything to say in your defense of the code violations?
Obviously, I was taken advantage of by the contractor. Basically, took off, parts unknown since, and left it in the state. It was actually a little worse. When I got back here from California, it was about chest high in debris, which I did work and got that taken care of and cleaned it up as much as I could. And it's definitely not because I don't want to be in compliance. Going a year and a half with basically living off my savings because I couldn't do it. I couldn't move in. I couldn't rent it. I couldn't sell it. I couldn't do anything with it in the state it was in. So I basically have run out of money. And I was unaware of I didn't receive any letters or anything. I was in California. I've been back since, I believe, last week of November, first week of December back here. And I have not yet started a civil complaint against them because it's still in the hands of the state's attorney, which we did notify in the Department of Professional and Business Regulation. They do have an active case against it. The investigation has been concluded. It's been referred to their general counsel to decide, basically, I think, whether they're going to actually charge him in a criminal court. In which case, I would have to wait till that was resolved, and then I can take civil action from that point on. So I haven't started actual civil litigation yet. As soon as the state finishes, which I don't know, they say it'll be when it'll happen when it happens. And in the meantime, since I spoke with the investigator, Mr. Cruz, I have obtained a loan finally, and I have hired to finish the bathroom, and I should get the final word. They said early in this week, so today, I guess Tuesday, Wednesday, I will know when the work can actually start. They will pull the new permits to complete the work. And I will do everything according to the way it should be done, have the city to inspect, or whatever they wish to do. And I'm trying very hard to be in compliance.
Do you, how much time do you think that you would need in order to get the permit pulled based on your conversations with the new contract?
As far as, I don't know how long the process takes once it gets to the city, but it should be, I assume, by the end of this week or the beginning of next week.
To at least apply for the permit?
To apply for the permit, yes, ma'am.
Okay. Anything further that you'd like to add?
Not that I can think of. Oh, just maybe a clarification on that one violation of the appearance of it. I'm a little confused on that because nobody could see it. It's like on the inside of my apartment. So that was kind of confusing. Other than that, no, I don't really have anything. And that wasn't a complaint. I just didn't understand how that was.
Okay, understood. And do you have any questions for the respondent?
Yes, and I will answer that question, but I do have one question. When did your contractor stop doing work at your property, roughly?
I have no idea. I'm going to guess the last summer, end of summer, maybe September of
September
last year.
2023?
Yeah.
So past, in
Past
your opinion, past May 1st?
Past May 1st, yes.
Okay.
And I was unaware, obviously, that he didn't respond to, apparently, the city sent the information to him.
Understood.
Which I heard earlier, but I was unaware of that till today.
Okay. And not directed to you, but Madam Magistrate, his question about unsightly conditions, subparagraph 1C specifically says, left in a state of partial construction beyond the valid time frame of the permit. So it wasn't actually visualizing it, but the code allows for this specific situation, which is why it was cited in the notice of violation.
Okay.
Okay, anything further?
No, ma'am.
This one I find a little bit difficult. The two cited code sections I do have a little trouble with. Section 98-123.1 says any applicant who intends to undertake any development activity basically needs a permit. You intended to have an activity, your contractor secured a permit, things went awry, and construction stopped. There's been no testimony to suggest that work was done after the permit expired, just that the permit expired. So I don't find that there's been a violation of section 98-123.1. However, I do find that there has been a violation of section 98-65 unsightly conditions with the caveat. The code section says that it applies, I had the same question that you did, Mr. Lauer. The code section says that it applies to structures that are left in a state of disrepair or left in a state of partial construction. I will have you know that that section of the city's code does not define structures and says anything in that section that is not otherwise defined. You refer to the Florida Building Code. The Florida Building Code defines structures as that which is being built or constructed. So the bathroom is being built or constructed. In this case, I guess it would be more like a reconstructed, but that falls under built for me as far as my interpretation of the Florida Building Code or of what those plain words mean. So I will find that there is a violation of 98-65 unsightly conditions, and I am going to allot. Do you guys know how is your building department running pretty quickly on permitting if everything is submitted?
We're basically at 30 days right now.
30 days.
We have 108 in queue.
Okay. So I will allot 45 days for the respondent to apply for and secure the permit, and then we will do a status check at the May. Will that give us enough time? When is the May hearing set for?
That one would be May 13th.
Let's do it for the June hearing. Well, May hearing gives us 60 days, right?
Correct.
So let's go ahead and set it for a status check for the May hearing to see where we are at and making sure that a good faith effort is had to secure the permit by that time period.
Thank you, ma'am. I appreciate that.
And
If I just want to make one
Yes.
point of clarification, because I did ask the property owner a question as to when the contractor stopped doing work, and he stated, if I'm not misspeaking for you, September of 2023.
Yes, yeah.
The permit
That's
ex-
what I was being told. Whether he was lying to me because I wasn't here, I have no idea.
I just wanted to make, that was the point of the question, is the permit expired May 1st of 2023.
okay, but okay. That is a good point.
I understand your point. I really, to be honest, it's speculation on my part because I wasn't here physically. And if he told me he was working, and I understand the permit ended on May 1st, I understand your point. But I really have no way of knowing if he was actually working past the permit date or not.
And does the city have any evidence to support whether or not there was work going on during that period of time? Because
No.
now I have evidence that suggests that it may or may not have occurred.
Were you told by your contractor that he was working on the bathroom after May 1st?
No, I was only requested to pay the final draft payment. It's the only thing.
So he didn't give you any status updates past May 1st?
No, except I kept asking for them, but I didn't receive it. The only communication I got from him was a request for more money.
Okay,
Yeah, I'm going to keep my ruling
That's-
as is based
that's
on
fair.
that evidence.
I understand. Thank you for your honesty.
Thank you very much.
And then we'll be back, like I said, at the May hearing. I will get you an order. Just make sure we have your current contact information to get you the order.
Okay, yes, ma'am. Thank you very much.
Okay, moving on to case 3C. Case number 20240051, City of St. Pete Beach versus Philip Parsons and Suzanne
Lamblot.
Thank you, Lamblot. Would the city like to go ahead and make its presentation?
Yes.
Thank you.
Stephen Rivera again, on behalf of the City of St. Pete Beach. Case number 20240051, respondents Philip Parsons and Susan Lamblot. Violation address is 4043 Bell Vista Drive. Violation description, the property is in violation of section 9866, residential and commercial property maintenance, A, B, 22, B1, 2, and 3 of the Code of Ordinance of the City of St. Pete Beach. Case summary, initial inspection, 1/23/2024. Notice of amended violation dated 1/24/2024. Notice of violation compliance date, 2/8/2024. Notice of hearing dated and posted to the property, 2/15/2024. And the following is a true and accurate representation of what I witnessed. This is the affidavit of posting. This was the overgrown vegetation on the 41st Ave side of the property. Corrective action, the property must cut back the vegetation so it does not impede vehicular traffic. The property is compliant, and recommended fine is $325 administrative costs. I do have a picture of the property being in compliance. You can see it's a pretty significant difference.
And do you know what date that property came into compliance?
I believe it was, I don't want to guess, it was right after, not long after I posted the property.
Was it before the date of compliance in your notice of violation?
It was not. No, it was the 15th it was posted, and the 8th was the compliance date.
Which is why it's in front of you, Madam Magistrate.
Yep, I understood. Yeah, I got that. Okay, thank you very much. Is there anyone here on behalf of the property owner? Okay, if you could please come up and just state your name and address for the record, and if you have any response to the city's allegations.
Hi, Susan Lamblot, and my address is 4043 Bell Vista Drive. My response is that the first time I was notified was the 15th, which is the day I moved in the property. So I got the notice on the door, and I called to speak with the representative to tell him I'd received it and I'd take care of it immediately. So I called the tree person and took care of it within 3 or 4 days. So I think it was on the following Wednesday. So I was in communication the whole time, but anyhow, I did not receive this first notice via mail, even though I was checking the mail since I received owned the property 11/1, and the trees are not actually on my property. But the original letter that was sent to me, certified mail, didn't actually get to me till 2 days after the amendment was posted on my property. So I just wanted to say that I was not technically in violation because I did everything I was told to do when I was notified.
Okay. Okay, does the city have any response to that? I mean, you don't have to, I'm just asking if you have any response to this.
We filled it out, this process, gave time for compliance, and posted the property with a copy of the notice of violation.
Okay. And you said the trees are not on your property?
No, but I mean, I took care of them, it's done, but they're not on, I brought my survey with me as well.
Okay, did you want to submit that as evidence to show
Sure, I
that they're
think I
not?
put that properly on the thing. Oops, sorry. Okay, this is harder than it looks.
Okay, and can you just tell me on this where the trees are located, if you know?
So the trees are on, right here on 41st. This is Bell Vista. So right here, yeah.
In between the, where you
Yes.
see the side of it and then your property line?
Yes, and they were overgrown with the previous owner. I didn't move in until the 15th, excuse me. So, yeah.
So, can I ask a question?
You may.
Right where you're pointing, ma'am, I'm assuming that's your driveway extending past your property boundary, correct? That wishbone looking, yes.
Yeah.
And the trees are right next to the driveway?
No, they're near the stop sign right here. This is the little stop sign, and this is like a little dog park right here.
Okay.
Okay, I've got the pictures of the,
And I took pictures, the same as he's shown that the work has been completed.
okay. If you don't own that property, do you know who does?
Between my property and the street, the city, I assumed.
And they're in the city rights of way.
Madam Special Magistrate, may I speak?
You may.
Property that is normally contiguous to the curb is maintained by the property owner?
Do you have a code that suggests, or the code that dictates that? Because under general property law, that's not the case unless the city dictates that via code. I'm just trying to look in the cited code section to see if that's. Because the cited code section says that the property owner is responsible for trimming shrubs or shrubbery, trees, et cetera, that are into the right-of-way or that overhang a tree, sidewalk, or otherwise impede or obstruct. But the argument here and the evidence presented by the respondent is that she doesn't own those trees. And I don't see anything that suggests that she should be responsible for maintaining trees on a city public right-of-way that she does not own unless there's a code that dictates that.
Is there a right-of-way permit?
Could we get a close-up of that survey?
Well, then,
Ryan?
yeah, madam, I can, is there a right-of-way permit? I'm assuming there was a right-of-way permit, because the confusing part for me is her driveway extends past her property
Could
boundary
we
as
get
well.
tighter?
And, I mean, realistically, if her driveway was, you know, damaged, the city wouldn't fix it just because it's in our property. There must have been some kind of right-of-way permit prior to her purchasing the property that allowed that there, along with the vegetation.
Well, or there could have been a permit that allowed the driveway to be constructed in the right-of-way, but not necessarily to allow for the vegetation to be planted. Now, that being said, that doesn't mean that there isn't. I just don't know if there's a city code that says if you've installed, you know, in many jurisdictions, if you install vegetation in your right-of-way that abuts your property, that's fine. You may or may not need to get a permit, but you definitely have the responsibility of maintaining it if you install it, or if you purchase it subject to it having previously been installed. I don't have a right-of-way permit in front of me. I don't know if it, and I don't have any testimony to suggest. All I have is testimony saying, I don't own that.
Do you mind if we take a 4-minute recess?
No, I do not. Is that okay with you if we just take a brief break?
Yes, I mean, sorry, and I know this needs to be worked out. My reason for coming here was to say that I did the work immediately when I was notified, and I would not have disregarded any other notification I was provided. So that's really what I called and told the representative in the beginning. So I think that's what I wanted to be cleared, is that I
and
did
what
not
I'm trying to
sign a
get at
violation.
is if it's not your property and there wasn't a right-of-way permit, then there may be other issues, but I don't want to assess you $325 worth of costs if it's something that you're not necessarily having to pay. Unless you'd like to go ahead and say, I just want it to be done with, I'll pay the costs and move on. It's up to you.
No, I mean, I would rather not, just because, you know, I moved in and this was
I think most people
this was my
would,
welcome to St. Pete Beach notice on my door, so, yeah.
Okay, yeah, if we
you.
could just take a brief, let's take a 5-minute recess, and we will be back in 5 minutes to finish this up.
Thank you.
You guys,
We can continue.
okay.
Yeah, we don't need, thank you.
Back on the record then.
Back on.
Okay.
As of, right now, there is no record of any permit for the driveway or for the landscaping, so the city will withdraw its
Okay.
case.
Okay, so at this time, the case number 202400051 has been withdrawn by the city. It is dismissed. And
Can we just make sure that we get a copy of the survey?
yes, you left one with us? Okay.
Thank you, ma'am.
I am actually going to do an order of dismissal just so that we have a record of what happened unless the city objects.
If you could just base it on the fact that we had no,
That it was voluntarily withdrawn.
I don't want to be prejudiced in the future if we find anything.
Okay, I can dismiss it without prejudice.
Yes, please.
I will do so.
Thank you.
All right. Thank you very much. Okay, and now moving on to agenda item 6A, we're on to lien reductions, case number 202100517, City of St. Pete Beach versus Quresh Bakatarian. Maybe? Would the city like to
Lewis, is this
present the
6A?
Oh, Pete's gonna. Mr. Dewar, would you be presenting the lien reductions?
Yes, ma'am.
Okay.
Morning, Madam Special Magistrate Pete Dewar, Code Enforcement Manager on behalf of the City of St. Pete Beach, case number 2021-0517. The city and the applicant has agreed to a total of $1,442.46.
You said 1442?
$1,442.46, please,
Okay. And that's with the administrative costs, or is that sand?
with the administrative cost.
Okay, how much?
Clarify, we've agreed to 10% of the total fines plus admin costs.
Thank you.
If you could please provide the magistrate
Math
the
on that?
total administrative fees, because I think the ones in the application are wrong.
$467
Even?
and 46 cents.
And 46 cents, okay. And the total fine amount was, the original total fine amount?
$9,750. There are no violations on that property, as well as the gentleman paid his taxes.
Okay, so it's a reduction to $1,442.46. That's inclusive of fines.
Correct.
Okay, is there anyone here on behalf of the respondent? Is it Mr. Bakatarian? I'm just butchering everybody's name left and right. Anyone here on behalf of the respondent? Okay, then it is agreed. I will go ahead and order the reduction in the fines, including costs, to $1,442.46, and get you an order to that effect.
Thank you.
Thank you.
All right, moving on to 6B, case number 202100528. City of St. Pete Beach versus 3503 Gulf Boulevard Holdings LLC. Mr. Dewar?
Overhead, please. Overhead. Please go to the overhead.
You're on it.
It is on the overhead.
Madam Magistrate, that case came before you November 8th. And you ordered on December 1st, $250 per day. The total fines came up to $10,966.95.
If you could, Mr. Dewar, I think it's easier to separate the lien and the administrative fines.
All right, I'm sorry. $466.95 is the administrative fine, and the lien is $10,000, $10,500. And so the city is going to ask the respondent for.
I think the respondent's
The
here.
respondent's the one asking for the reduction in the lien.
got it.
I think based on the application, they're asking for 0.
Well, that was going to be my question, because the application doesn't
say an
list
amount.
anything. It says just the administrative fees.
So you have that in front of you.
Correct.
I do.
Part of the agenda.
This one was on the agenda, the other one is not. Okay, so if you could please just state your name and your address for the record, please.
Hi, Chris Witz, 3503 Gulf Boulevard.
Okay, and because this property is owned in the name of an LLC, what is your affiliation with the LLC?
I'm with the other half of the LLC, Family First. I work for Family First, with Ellison is the primary holder of Family
Okay,
First.
and so you have the authority to
Yes.
negotiate this lien? Okay. And what is it that you're requesting, and can you give me your basis for that?
No, just that we did, I mean, with talking to Pete on, a couple of occasions, that we did come into compliance immediately when we found out the situation. And this is embarrassing that we're here. We should have been here a long time ago, getting this resolved, and just simply got busy, been a little embarrassed about the whole thing.
Okay.
But just would like to see the best we could to reduce the fine as much as possible. Asking for none, but, maybe 1,000 or 2,000 would be preferable.
Okay,
May I ask a question?
you may.
How much did you make on the rentals that you were found in violation
I
of?
would honestly have to go find out.
What's your nightly rental?
It would vary back. It hasn't been rented in 2 years, 2.5 years. That would go back to when it first happened. Because immediately after the notice, we got the place cleaned up a little bit, we put it on the market. We actually own it with some friends of ours. And at this point, we put it on the market for basically 2022, got a couple lowball offers, didn't take it. And then subsequently, we're looking to purchase it from the other partners. And just working on some financing now.
Understood. I have no questions. I just need to confer with the city real quick.
Okay. You may confer. Thank you very much.
Am I done up here? Or?
You are done up there. Yeah, I'm not going to make you stand there while they...
So I think the city's position for short-term rentals, since it's a zero tolerance policy, we are willing to reduce it to 25% for the fines, which...
I was going to say, can you do that math for me? Or are you going to make me do the math?
No, the total fines are $10,500. 25% would be $2,625 plus the $466, plus the admin cost, which I believe were.
$466.95.
Thank you.
Is that agreeable to you all? Okay, and I understand the city's position. There was a violation. We're looking for, at least I'm looking for evidence of a good faith reason why the total fine shouldn't be had. It was a violation of the short-term rental ordinance. And I understand your position, but I am willing to grant the reduction to the $2,625 and the administrative costs of $466.95, and I will get you an order to that effect. On all of these, I'm giving 30-day time frame to pay. Is there anything?
No.
Okay.
30 days is exactly what the city wants. And I actually like that language, if you could keep it in that if they don't pay it,
Then it comes back.
Yeah.
Yep. Okay. Anything further? I think we're good on that one.
Correct.
And then we're moving to the additional agenda item 6C, case number 20230255 for 471st Avenue. And I do not have any information on this, so
Please pull up what we have on.
Before you start, can you pass out, or at least to Madam Magistrate, the packet?
Thank you, Mr. Dewar.
Thank you.
And it's on the screen. The application. And the taxes that were paid. The owner of the property at the time provided a power of attorney. I think the owner is here, Ms. Jordan.
Her representative.
The fines totaled, the lien was $42,500 with administrative costs of $449. And the details of the property indicating compliance with the requirements for lien reduction.
Okay, and my quick question is, this property, the violation was under a previous owner, and the reduction is being asked by the new owner, is that correct?
So, and I can clarify that,
Yeah.
if I may.
If you would, please.
I also have the prior order if you want me to show it on the overhead, but essentially what occurred is on October 9th, 2023, Madam Magistrate imposed a fine. This was one where, if you remember, Ms. Jordan had a realtor. She said she had a contract. She didn't.
She didn't,
It was one of those situations.
I do recall that
So you assessed a fine back to May 23rd, 2023. My office was contacted a couple months after related to a potential sale. We agreed, we did not release the lien, but we agreed that we would allow the prior property owner to do this with the understanding that they would hold money in title for an additional 90 days of compliance for the new property owner.
Okay.
We haven't initiated code enforcement proceedings on that because the new property owner has applied for a permit and whatnot, but this money was withheld from the prior owner.
Okay.
So we're allowing her to ask for a lien reduction now that the ownership has changed and we feel comfortable with the compliance steps that the new property owner is taking.
Okay, so the reduction would apply to the previous property?
Correct, so the money withheld is from,
Is for Ms. Jordan?
correct.
Could we go to the O drive, please? And what you're looking at is your order. I'm going to start from page 1.
Okay, yeah, I recall this one very well.
Thank you.
And I won't speak for the title company, I believe her representative is here, but I believe they withheld 60-something thousand. Again, based on the compliance deadline that we're working towards, so.
Okay. If you could please come up and state your name and address for the record.
My name's Susan Adler. I'm with Monument Title. I'm Kimberly's power of attorney for today.
Okay.
My office address is 11307 Little Road in Newport Richey.
Okay. And since this is Ms. Jordan's lien reduction request, what is she seeking to have? It looks like just $3,000 plus.
She is seeking to have it brought down to $3,000. She had to sell the house at a significantly lower price because of all the work that had to be done. And withholding the $66,000, I withheld almost all of her proceeds. And unfortunately, she misspoke at her own hearing. I had already started the work for the title when she came to that hearing prior. And we did close 30 days later. We closed on November 8th to the new buyer who started working on the property.
Okay. Okay, so she's requesting the $3,000. And you said it was 66 held in title, and those are, okay, okay. Anything else that you'd like to say on her behalf?
Just that she did everything she could to sell it because she knew she couldn't maintain the property or repair it. And she's tried to do the right thing by selling it to somebody she knew would
be
benefit the neighborhood, yeah.
Okay. Do you have any questions for the town?
No, I don't. I don't.
Anything further from the city?
I think, yeah, I'm just working on the numbers, Madam Magistrate, real quick, based on the direction I'm getting from the city. So we understand, and I do have one question, actually. So once we reduce this, whatever's paid to the city, the remainder will go to Ms. Jordan?
Correct.
Correct? All of it?
Yes.
Okay. For consistency purposes, Madam Magistrate, and understanding Ms. Jordan's situation and what she's trying to deal with, the city's agreeable to 10%. So I know she said 3,000, but 10% is as low as we usually go for these types of things. That would bring the total lien to $4,250 plus the administrative costs.
All right, and the admin costs were the $449.
And then I guess with this one, if you could, which I believe you already had language like this, if the magistrate's agreeable to this, the moment we're paid, the city will release the lien on the property.
When yeah, I think there's language in the order that says when it's paid and once it's cleared.
Cleared, then
the lien will be released.
Okay.
Okay. I'm going to grant the lien reduction. I understand Ms. Jordan's position. I do think 10% of the fines is reasonable, and especially having had so much time for Ms. Jordan to bring the property into compliance or sell it. So I am going to grant the lien reduction to the $4,250 plus the $449 in administrative costs. Typically, we grant 30 days to release the funds. However, this is being held in title. You have the ability to pay that.
As soon as I have wiring instructions, I can release it today.
I am going to reduce that to 2 weeks. You shouldn't need that much time, but that seems reasonable enough to me in case there's a hiccup. So you will have, Ms. Jordan will have 2 weeks to pay the reduction in fines, and upon payment and clearing of the payment, the city will release the lien on the property.
And I can get wiring instructions from you.
Yes, from the city right after this.
Perfect. Thank you.
Thank you, ma'am.
And I will get you an order to that effect. And Ms., is it Nadler? Yes. Did you want me to send you a copy of this order to give to Ms. Jordan, or should I send it directly to Ms. Jordan?
She's bouncing between family right now until she gets the rest of her proceeds, so if you can send it to me.
Okay, and that's the email address that you put on the application. Okay, I will go ahead and send the order to that email address then.
Thank you.
Thank you. I do not have anything further on the agenda. Is there anything else that needs to be taken care of while y'all have me?
That's it, ma'am. Thank you.
All right, then I will see you all in April.
Very good. Thank you. See you in April.
I'm going to be more long-winded on these.
No.
I wrap up these